Hello, everybody. Oh, goodness. I'm all wonky. What's going on there? If only there was a formula. That's not why we're paid the big bucks. We don't get paid the big bucks for following a formula. Oh, dear. So there's a little bit of anxiety on the isn't IRAC a formula. It's called a set of training wheels. As we all know, towards the later progression of our degree studies, we will more than likely kiss a loving goodbye to the constraints of IRAC. But it does give us some structure within which we can start our skill development in crafting a beautiful and eloquent legal argument that compels the lecturer to give you a high distinction. You're hating the assessment. Wow! That is a strong word. I'm hating the assessment. Well, you know what?
I am deeply upset. I'm deeply, deeply upset, AJ. It's not an easy one.
It's interesting because, you know what? There's no real right and wrong answers, is there? I mean, there's clearly going to be answers that are more right than other answers. And there will be answers that are more convincing than other answers. But this one really comes down to your ability to make a good argument, a really solid argument. Don't have nightmares over this. It all comes down to your case knowledge. And if you are familiar with the cases that have grown out of the jurisdiction where the assignment is set, and then you look at, oh no, Amy Lee, if you look at the overall development of the other more recent case law, you will get a feel for how judges have been throwing around this issue. And you will have some, like the judge obviously in the Reese case, that's come out fairly pro-equity. You've got others, like the court in Australia States, that have come out the other way. And you've got great peace, which gives you no great peace. Bad contract law lecturer joke. Which gives you a fairly commanding review of the landscape. And then really it's a matter for you to stitch it all together, isn't it? I mean, the High Court hears things de novo, so, you know, really what will sort the sheep from the goats with this assessment is your ability to, John, I think someone's getting a bit of reverb, is your ability to construct that nice, compelling legal argument and demonstrate your mastery of the case law to support which way it is that you want the court to come down. I mean, obviously you're arguing for a person that has vested interests in the court upholding one particular view. So your best plan of attack is fortifying your arguments with all of the case law that client has at their disposal. And there is some fairly formidable case law out there, isn't there, on your client's side. I've deliberately pitched it so that you're acting from malice because I know how early stage law students have this insatiable need to correct injustice and act for the party that has been wronged. And so I'm pushing you into perhaps uncomfortable territory in having to make arguments for malice. But there you go. Such as it is, sometimes the clients you get aren't necessarily the clients that you always want, and so the arguments you end up making before the court aren't necessarily the arguments that you would wish to see upheld in the highest court of the land. But there you go. And no, Tammy Lee, I wrote this with you in mind. Oh dear. Yep, I know. You contract A's, you see. I know I got your number. I got your number down pat. Gave you an assessment I knew you'd love. Now, someone here has said, can you please explain the idea of argument and how to form persuasive ones without being narrow-minded? Well, it's completely, who am I talking to, 1 + 5? What shall I call you, 1 + 5?
That's me, Jay.
Hi, Jay. Hi.
Sorry, I didn't realise that was my phone name.
That's okay. You know what, Jay, I would suggest reading my IRAC top tips.
Okay.
And if you haven't, then you may be attacking your assignment preparation not in the order which I have suggested, and that causes me some pause for concern. Really, I do need everybody to literally follow those steps that I've set out for you on the second page of that assignment. You need to do them in that order. Okay, because only in that order will everything make crystal clear sense to you.
It's also to do with wording of sentences. So if you're actually trying to make an argument and you're trying to form a proper sentence without becoming very kind of narrowed in your conclusion of a sentence, is there a way to make it so that it's still open-ended but still persuasive?
It all comes down to wordsmithing, doesn't it? And this is a skill which you are not expected to be masterful at yet. Okay. But first and foremost, you need to bear in mind that you aren't coming at this afresh in terms of you're not sitting on the High Court making the judgment here. You have a client and a job to do. So it's about making your argument as forceful as you can by your excellent knowledge of case law. It's about knowing the levers to pull that exist within the current landscape of case law.
Thanks.
So I know that that's really general. That's a really general. I'm not intending to be dismissive, but what I am intending to say is, if you bear in mind at all times you have a job to do and you have a client to get over the line, that will drive the way that you construct your sentences. I'm not sure I completely. It's not about being narrow-minded. It's about having your client in mind. Okay, there's a difference. Narrow-mindedness suggests that you think of something in a pejorative sense. You're being narrow-minded about something and not considering all the options. Part of that is it's a loaded term. If you're saying someone's narrow-minded, it means that you believe that they should be something else. Now, in terms of first-year law, you've got to some extent, put your preconceptions about wading into an argument with an open mind and willing to consider all of the options. That's not your luxury when you have a client in mind. It's your obligation when you are a judge on a bench. It's not your obligation when you have a client in mind. Now, having said that, you never advise your client that they're going to win a case if clearly they're not going to. You don't ever advise them to wade into litigation if you don't give them a realistic appraisal of what they're in for, right? But once you're in front of the judge and once you are making your submission on paper here to me, you need to be arguing the best case that you can put forward for your client. That's different to being narrow-minded. Can you see the difference between the two?
Spot on. That was perfect. That answered it. Thank you.
Sweet. No worries. Any other questions? I'm just looking here. A lot of hating on the assignment. Not much else. Amy Lee, we need to have a chat after class. It sounds like you're scarred. Oh no! Anyone who's concerned, please stay behind, and we'll have a little pep talk, a little bit of a discussion. We'll get you all back on your way again. We have a job to do this evening, though. So unless we have any further comments, okay, Tammy Lee, yes, you're right. It's about using the cases that will help Malice and not the ones against him. Yes, do know what the other side will argue. Yes, absolutely, absolutely. So you've got a job to do. The High Court. It's almost a 50-50 proposition, isn't it, really? I mean, you would have said to Malice, this isn't going to feature in your assignment, but in the prep you would have said to Malice, look, this could go either way. We honestly don't know. This is where things stand at the moment, but if you want to push on, push on. Now, he's obviously said we want to push on because Benevolent's taken it up to the High Court. He clearly wants to hang on to what he's got, so he's going to give it a red-hot go. It's up to you to convince the High Court that your client's position in law, as best supported by the case law, is the one that they should adopt. Okay? We'll revisit that at the end of the Zoom this evening. You probably cry. No, please. All right, let's get our job done and then we can get back to the assignment chat. I will, as always, share my message screen. And I will, I created a form and then I typed all over it. Messily, which was rather unfortunate because now I'm going to have to delete everything. And then you're going to have to tell me what I want to see here. All right. Let's quickly recap on duress. What's it all about? What is duress all about? In 25 words or less.
Isn't it all about forcing or bullying somebody into some sort of contractual obligation? Yes,
it is. It absolutely is. And that is the hallmark of it. Force, really, isn't it? Now, let's see. I'll take some of my little... Is it a common law action or an equitable action? Oh, I've got people in the chat. Sorry, people in the chat. My chat box keeps getting hidden. Common law. Yes, it is. Oh, Paris still wants a paddle. It is a common law action. Oh, I'm repeating myself there. It's a common law action. We know that the hallmark is force, or what's another way of putting that?
Undue.
Sorry, what was that?
Undue. Undue.
Yes, I'm thinking specifically in terms of what that forceful conduct does to the victim's will.
Their will
Doesn't
is
it take it away?
overborne.
Sorry, Amy Lee, what did you say?
Doesn't it take away their will? It's taking it away and forcing them to do something that they might not want to do due to another reason, a threat or something.
Yes, exactly. So we say that there has been coercion of the plaintiff's will, and that goes towards the issue of consent, and therefore, if you are successful in an action of duress, what happens to the contract? What is your potential remedy here? Oh, is it void or voidable? There was some discussion about this, bit of argy-bargy in Barton and Armstrong. Tuna saying voidable. Deval saying voidable. Tammy, voidable. Steph saying void. Paris saying void. You know what? You would think it would be void, wouldn't you? Because normally, from our discussions in mistake, we have the common law marching in to give you a cause of action. It's generally rendering the contract void. Here we have a common law action that renders the contract voidable. And as I said, there was a bit of argy-bargy about that in Barton and Armstrong. If you really, if you're an insomniac and you want to go back and read the case, it's quite an instructive case. So it renders the contract voidable. Now, we have a few different kinds of threats that might be made. Threats to, what's the first kind? And this was at issue in Barton and Armstrong.
Is this where we're talking about person, property, and economic duress?
Yes. So that's it. Threats to the person, threats to one's property, and economic. Now, economic duress might not be achieved through threats, but it might be achieved through what they call illegitimate pressure, yes? So perhaps not something as crass as a threat, but nevertheless the implication is still there. Okay, cases can we have, please? The biggie. I've already told you what the biggie is here. Paris, you're right. Yes, physical, monetary. The big go-to case. And he says, sign them contract or I'm going to have you wiped out. Yes. Lovely little case. Lovely little case. Threats to property. I also love this case. Come on. What better case law do you get than this? Tuna. Oh. Charlene's got it. Yes.
The helicopter?
Yes. Yes, the helicopter case. Isn't it lovely? Isn't that a lovely case? Please paint my helicopter. Okay, does a really crappy job. Oh, hang on a minute. You've done a crappy job. Please fix it up. Sure, we will. We just won't let you have the thing back until you sign a waiver that you're not going to allege any further crappy workmanship. Lovely. Economic duress. What's the case there? Ha ha. Tina, yes. You're on fire tonight. Sneefa. North Ocean. And Hyundai. Or if you're really old like me, we used to say hi undue. What did they do in that case? What happened in North Ocean? It was about tankers. Yeah. Snafer's got it. Yeah. Fixed price. Tankers. Please give us more money. Otherwise, we won't go through with the contract. Yeah, 10%. Yeah, drop in the US dollar. That's right, exactly. So that was a nice little extension of this cause of action. However, it's gone very, very deathly quiet, and that is largely due to the great uprising of, that sounds like a historical event, doesn't it? The great uprising of undue influence and unconscionable conduct. Undue influence, let's go on this because that's the focus of our little scenario this evening.
So this one all about the fiduciary relationships and one being in power, one being weaker, and then the person in power using that over the weaker.
Yes, absolutely. Captured that to a T. It's all about the capacity to influence, isn't it really? And that is done via, usually, a relationship. So it's all about relationships here. Is this a common law action or an equitable action? Haha, yes, the chat box is on fire. Equity, yep, equitable action, absolutely. If you haven't done equity and you are a bit confused about what equity is and how it works, and you want a very unsatisfactory and generalized introduction to equity, my video on equity and the way that it interacts with contract is up on Moodle for you, so you can go and knock yourself out with that. What enlivens equity's jurisdiction here is the unconscientious use of you as the stronger person, your ability to affect the other party's will. Okay, so again, we have the hallmark being coercion of will. Okay, this is what duress and undue influence share as their focal point. Okay, being an equitable cause of action, it is the naughtiness inherent in using your position of influence to get something. Okay, that's what sparks equity's jurisdiction here. In terms of the common law, you have the force affecting the will here. So here you've got someone improperly using their position. It affects the plaintiff's will. Their will is overborne. Here you've got someone doing something as crass as making some kind of threat, but same effect. The plaintiff's will is overborne. Okay. I think probably Amy Lee summarised that very nicely for us. I'll just do a cut and paste. So there's a relationship that bears a fiduciary characteristic. Now, for those that have done equity, you will know that fiduciary characteristics just is a fancy Latin-esque term for a relationship of trust and confidence. Okay, so we got one party here in a position of ascendancy and one party in a position of reliance. Okay, tell me a little bit more about the classes of undue influence that we may argue. Class 1. Can someone run through the elements briefly of a class 1 instance of undue influence? Otherwise, I can just do a cut and paste here. Actual, oh lovely, thank you. Actual undue influence, that is exactly it. And you've got to go and actually prove everything here as a matter of fact. So it's not quite as handy as class 2 undue influence, because class 2 undue influence, we get the benefit of the presumption, don't we? So actual undue influence, you've got to do all the work as the plaintiff, okay? You've got to show the other party had the capacity to influence your client. You've got to, and this is the bit that may cause some difficulty. You've got to actually show not only they had the capacity to exercise influence, but they did so, and as a result of the exercise of that influence, you've had this impact on the victim's will that's been overborne, okay? The exercise was undue so as to spark equity's jurisdiction. So you know wherever equity is concerned, before it can step in, there's got to be some kind of naughtiness somewhere, some kind of fishy conduct that's kind of on the nose. Unless you got that, equity's not going to touch it. So there has to be undue influence to the extent that equity can step in and the conduct brought about the contractual transaction that you're worried about and want to set aside. Okay. That will normally, you'll go about arguing that really as a bit of a second option, really. If you have the option of arguing a class 2, you're going to go ahead, as I said before, and argue a class 2, are you not? Because, as I said, you've got the benefit of the presumptions. Class 2A, can someone give me, yell out some of the relationships that we're looking for?
Parent, child.
Yep.
Guardian, ward, solicitor, client.
Yep.
The religious influence one and devotee was a bit of a I did not know for me.
Yes.
And Khan blew my mind.
I know, it does. It's quite shocking, isn't it? And given that it's not like many years ago, like Allcard and Skinner, it's like it's quite recent. Yes, so a little scary. I will just do a quick copy and paste there to pop all those different categories up here. Religious advisor, some of these will be very clear, and the extent that you have to go to improving the relationship will differ according to the strength of the relationship. So clearly where, for example, you have a parent and a very young child, it's going to be a very clearly recognised relationship of influence, and all you really have to do is you need to go about proving that relationship existed. However, where you have something like a religious advisor and devotee, it is, as the text said, a little bit more of a grey area, because there is a very great spectrum, isn't there, of people that might be in that kind of relationship, and some of them may be more able to influence than others. So the text says that in that kind of a situation, you do need to show that there was a reliance by the victim, and that the reliance, dependence or trust led to that ascendancy. okay, that stronger position on the part of the defendant. And then the court will say, oh, yep, you're in this particular relationship. We will raise the presumption for you. So if you're lucky enough and you've managed to convince the court that your client falls into one of these relationships, assuming that you're acting for the victim, what does the other party then need to do to try and rebut that presumption? You've got to show two things. Firstly, that the donor knew what they were doing. Yes, thanks, Tammy Lee. And then you've got to show that they acted independently. Yes, without influence. That's right, exactly. Because essentially what you're trying to do is rebut the notion that their will was overborne. Okay, so what essentially the argument you're trying to make is, no, their will wasn't overborne at all. They gave free and voluntary consent. Now, in order to do that, you've got to show they knew what they were doing and they didn't do it because of the influence. Okay, that will then negate whatever relationship that you're in. Okay, the presumption that arises with that relationship. Yes, the best way, thank you, thanks John. Yes, absolutely. The best way to go ahead and prove this and rebut that presumption is showing that they had independent legal advice. You read my mind, John. You read my mind. Or option to obtain it. Not sure where you're going with that, Tammy Lynn. Okay, class 2.
Sorry, I was just thinking whether or not they were given the option to obtain legal advice. You know how when you sign a car contract, for instance, they say, well, before you sign this, you actually have the option to go and seek legal advice first. So if they were given the option to and they chose not to, then that's showing to me free will, that they chose not, that they had the option to seek it and it probably was in their best interest to do that, but they chose not to. Sorry,
yeah.
Yep.
Exactly. You're trying to scrape together every little shred of evidence that you can get to show that you gave them the opportunity to act in a manner that was free from their influence. Class 2B, dear old Johnson and Buttress. Poor little man. What happens with Class 2B? What's the general go? Yes, there is an antecedent relationship, but it doesn't fall into Class 2A, does it? So it's not within these very clearly recognised categories of influence. Okay? Doesn't fall within that handy-dandy stack of relationships there. So what are you got to do then? What do you need to show? Comes out of Johnson and Buttress. Someone said no irrebuttable presumptions. No. Most presumptions in contract law are not irrebuttable. Most presumptions in contract law are rebuttable. Okay, so what do you need to show here?
Show that there is a dependency in the relationship, and again, if somebody has that influence.
Exactement. Yes, Steph also saying dependence or trust on their part. Samantha's also saying exercise dominance due to trust and confidence. Exactly. You have to show that that stronger party, the other party trying to enforce the contract, had ascendancy due to that relationship of trust and confidence. And if you can do that, then they will naturally assume that there has been a relationship of trust and confidence on the weak party's part and the ascendancy on the other party's part, which then is the breeding ground for undue influence, is it not? Okay, in 2 quick minutes, let's briefly recap unconscionable conduct for no other reason that I think it's super important. And when I redesign these materials, I will more than likely do a tutorial just focusing more on unconscionable conduct. But the way that the unit is set up at the moment, I actually don't mind it, because given that we focus on kind of undue influence tonight, it kind of leaves the way open for assessment down the track, and I'll often chuck in something to do with unconscionable conduct somewhere in the assessment somewhere down the track. So more than likely not the last we will see of unconscionable conduct. If nothing else, then Commonwealth Bank and Amartyo is probably one of my all-time favourite cases of any subject anywhere. So, yes, Samantha's really hit the nail on the head here. Love that this is so broad for special disability. Absolutely. So you can see the way that this is why we do duress, undue influence, unconscionable conduct all in the 1 week, because it allows you to draw the connections between everything much more clearly than perhaps if you'd done, duress in week 1 and unconscionable conduct in week 5, and you know what I mean. You can see that you've started with this rather narrow concept in duress at common law, and then it's kind of morphed into economic duress. It's starting to kind of get broader, but then, equitable courts have been frustrated at the limitations there to a focus on force and threats and all that kind of, as I said before, kind of crass behaviour. And they've wanted to give an answer or a remedy in other cases where the focus is not really so much on the threat, but the focus is on how the influence has been massaged over that victim of the conduct. That's where you've got undue influence creeping in as an equitable doctrine. And then you've got, bam, Commonwealth and Amartyo, which just brings out unconscionable conduct as a real fighting force of itself. So really, you've seen in other areas so far already equity's concern in contract law, haven't you, in terms of in contract A, where you were talking about capacity and you were talking about minors and drunken parties and so on. There's that concern to protect interests there. You've seen with mistake how equity has obviously crept into the bargain there. You now are looking at unconscionable conduct here, undue influence, but really the naughtiness at the bottom of it, as I said to you before, that allows equity to spring up is what is the enduring theme. And the naughtiness really is just unconscionable conduct that would offend the conscience of an equitable court. So you've got that popping up, as I said, in all those different areas: mistake, undue influence, capacity. And now with Amartyo, you've got unconscionable conduct really being called something for what it is. It's just, okay, we don't even have to have all the fanciness of undue influence. We can almost cast ourselves free and just focus on the naughtiness. And that's what unconscionable conduct allows us to do. So we shift from the focus being on the coercion of will, as it is under duress, and it is under undue influence, and the court shifts their focus now to the stronger party. What have they done? Have they taken advantage of the weaker party's special disability? Can you see what a step change this was? Amartyo is a really super important case here, and that's why you might have got sick and tired of the text kind of banging on about, it's all of these actions have been kind of subsumed by unconscionable conduct, And that's, I hope I'm kind of giving you a flavour of really where the case law has gone, because this is really a super important shift. So we have one party, consent is the result of their disadvantageous position, and the other party taking advantage of that. Yes, Tammy Lee, you are right. Meant to be store. I haven't read that case, Samantha. Yeah, Amy Lee, that was Commonwealth Bank in Amadio. Mm-hmm. Yeah.
Oh, I work there. That sucks.
Well, no, not really, because it's taught us all a very valuable lesson, and it was very jolly nice of them to do so.
I think Combank's had enough. I think it's time to get out of the limelight, Combank.
Yeah, banks and their naughtiness. Where would we be in contract law without banks and their naughtiness? I don't know. Okay, so we have this Rich. Yeah, Tammy Lee. That was very quick. I'll pay that. Let me just copy and paste, and I'll whack this answer guide for us up, later on in the week. But the elements are just, the proving of the special disability or special disadvantage and the taking advantage. Okay, renders the contract voidable. So quick 20-second recap. Difference between void and voidable. Voidable, there are bars on this remedy, are there not? And can people shout out to me very quickly few of the bars on the equitable remedy of it being voidable? If it's voidable, it means that affirmation is one, yes. Delay is another. Intervention of third-party rights, they are the big 3 ticket items. Yes, you're right. Okay, so not the same remedy as it being void. Void, it's as if the transaction never even happened in the first place, cannot pass the title through to third parties. Voidable, if you don't actually step up and ask for rescission, ask the court to avoid the contract before an innocent third party intervenes, you've lost that remedy. Okay, super important difference there. Alrighty, let us have a wee look at, oh man, this was anybody else disturbed by this tutorial scenario? He was a rather awful, he was a rather awful husband. I call him horrible husband. Anyway, let's have a quick look.
Please come in and sit down, sir. I can tell you're pretty angry right now, and I'd like to find a way to help you.
You're damn right I'm angry. Bloody hell. My wife is a wonderful woman, but she's been a complete idiot this time. It's a mess.
Messy situations are my specialty. Tell me what's happened.
My wife, Livia, is a very religious woman. Me, not so much. But she's right into it. Every time something goes wrong in her life, she's straight down to the church to tell the pastor all about it.
Okay.
Don't get me wrong. I got no problem with that. I'd rather it were him than me listening to all that yap 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 all the time. Wonderful woman, my wife.
So I gather. Go on.
All right. Well, here's what happened. We have a car we want to sell. It's a good car. Probably get $15,000 for it. But we want to move it pretty quickly. So we've put it on some websites for 12.5.
Have you had any luck?
I guess that depends on what you mean by luck. We sold the car all right.
Isn't that a good thing?
Not under the circumstances. Livia was telling the pastor all about how we are selling the car. Turns out he was looking to buy a car. So far, so good. But then he starts telling her he couldn't afford the price we were asking. He starts telling her how happy God would be if she sold the car to him for $9 grand. $9 grand. Apparently such a wonderful act would send her straight to heaven and cleanse her sins or something. I don't know. Anyway, she fell for a hook, line, and sinker. Next thing I know, she shows me the check and says she has sold the car.
Goodness me. Okay, has the pastor actually picked up the car yet?
What? You think I'm stupid? I told him no way he was getting the car, not until I talked to my lawyer. I haven't banked the check either, but he insists that a deal is a deal, and now my wife has come down on his side. To make matters worse, now I got a potential buyer on the website who is ready to pay me the proper price. So what do? Do I have to give the car to the pastor, or can I sell it to the guy who wants to give me a proper price?
Let's think about it.
All righty, let's let's think about it. Okay, let's review what we've got. Actually, let me just delete everything so that you can do the work and tell me the answers. Olivia's religious. He's not. Every time something goes wrong in her life, she runs off to the pastor. First factoid that we may file away in our client's armory of useful facts. Better than the pub, healthier than the pub. He wants to sell the car for 15 grand, sell it quickly online for 12 and a half. We have a query. My first query here is who has title to this vehicle? And I'm assuming for E.
It says both on the tutorial question. Like there's actually something on the question that says they both have title.
I would say for our purposes, just to make it easier, that we can assume that she can sell the car, given that she has purported to do the transaction and has taken the check. We can talk a little bit more about title afterwards. Let's just deal with the undue influence argument here, and then we can, talk about niceties later if we've got time. The pastor says he needs a car. She says that they're selling. He says, she says 15 grand. He offers 9. He says if she accepts this, God will be happy. She'll go straight to heaven and her sins will be cleansed. Obviously, that's a fairly bare reference to calm. She accepts, sells for 9 grand, takes the check, goes home. Horrible, annoying and misogynistic husband says that he doesn't want to sell, runs to the lawyer, has a buyer online, 12 and a half, wants to sell to them. Okay. God will be very happy. Oh, man. You wouldn't believe that this stuff went on if it wasn't for the fact of cases like Calm very clearly showing you that it does go on. Queck and Beggs, I thought, was equally quite disturbing. Yeah, I know. And some of the things that the Mufti says to poor old Mrs. Sadiq really are quite ominous. And yeah, it's kind of hard to believe, but there you see it in black and white. So one-liner for the issue here. Whether Olivia or husband may, what do they want? Am I willing to fork out 5 grand to my lawyer to get 3.5 more for my car? There you go. Yes. May resume the sale by arguing. Yes? Thanks, Samantha. Yep. Okay. Rules. Hit me with them. Undue influence may be established. So clearly we're going to try for what? Are we going to go to all the bother of arguing a class 1? Do we need to? What class are we arguing here? Yes, Amy Lee's saying 2. Yep, John's saying presume. 2A, yep, 2A. Yes, and that's the thing that surprised me about Khan. What did they argue Khan as a case of? Class what? Yeah, Tammy Lee's saying actual. So they argued it as class 1, which they didn't need to very clearly. But there you go. I guess maybe they got, cheapo lawyers are us. They would have had to have done a lot more footwork to argue a class 1. Okay, so for class 2A, we will get the benefit of presumptions, will we not, if we can demonstrate the requisite relationship. So what's the relationship that we're going to be arguing here? Tammy Lee said recognise. Yeah, Amy Lee, religious advisor and devotee. Yep, that's exactly right. So if we can do that, the presumption's raised, and we've talked about what we need to show if the other party is going to get around our arguments. Okay, all right. Application. So I'll start you off and then you can dazzle me with your brilliance. Oh, let's keep that all together, shall we? Shall we? I'll just tidy this up. There we go. Beautiful. All right. The relationship of spiritual advisor and devotee is recognised as one of obvious influence or natural influence. Can we plunge now into case law discussion, please, as I like to see you do? If you're in the middle of writing up your assignment, please, as I said, stop until you've read my IRAC top tips, and then you'll know how I like to see you crafting a good argument, okay? Generally speaking, you'll start with your discussion of case law. So where are we going to start here tonight, people? Which case would you choose? Johnson. Well, you see, Johnson was a case of class 2B. And I think this one fits very nicely into 2A, particularly because we have a case that is quite similar to this one in terms of spiritual advisor and devotee. Khan, yes, Amy Lee. I also went Khan and Queckenbegs. Shalifa, Khan, Hardigan. Okay. Send me in those IRACs, people. I didn't get many this week. You're all too busy on your assignment. Okay, so I would probably launch into Khan and Khan. Someone say something for me about Khan and Khan. What eloquent words would you put around your discussion of Khan and Khan? In Khan and Khan, let me start you off. In Khan and Khan, interestingly, these are the things that HD students whack in there if they've got enough time, but they're not essential. Interestingly, it was a case of 2A, but they argued class 1. In that case, what happened? Dear old Mrs. Sadiq, I did feel sorry for her. Too busy crying myself to sleep with the assignment. Come on, we've got to have some therapy at the end of this. In that case, what? The Mufti was what? Was he the party that was going to get the actual benefit, the Mufti? So in Queckenbegs we had, interestingly, a bit more similar, didn't we? No, that's right. Exactly. That was a case of third party undue influence. So in that case, the Mufti was a third party, but the person that was seeking the benefit of the contract, that was seeking the benefit of the Mufti's undue influence, was the one that was wanted to keep the contract on foot. So the Mufti was really intervening on behalf of the third-party beneficiary. That third party knew about the influence of the Mufti, and that is what tainted the third party with the Mufti's undue influence. That's how it worked in Khan and Khan. The Imam,
wasn't it the family members that were trying to, saying that they had an honourable, like they had to keep going with it just out of honour. They had to, that she should keep going with the deal out of honour. And so it was, I think, her family member or her son or something that was trying to get her, that brought in the spiritual advisor to try and convince her to continue with the deal.
yes, it was, but how is that? Let's think about our elements and what we would need to be proving. It's really in terms of the person that's seeking the benefit to keep the benefit has to be tainted by the Mufti's. Whether or not the son called the Mufti in is almost irrelevant, because what you have at the end of the day is a weaker party, a person of influence, and a party at the end of the day that is seeking to retain the benefit of a contractual transaction. So whether it was Mrs. Sadiq's son, which it was, that called the Mufti in or not, is kind of a bit by the by, because at the end of the day, the party seeking to retain the benefit of that contract was tainted by the undue influence that was, thrown into that situation by the Mufti. Does that make sense to you, Tammy Lee? I'm sorry, I'm kind of going this way, but I've got.
No,
I've got
right. Sorry, I think I misunderstood when you said the person retaining the benefit of it. I thought you meant was the person buying the house, but are you saying the person retaining the benefit is the actual mum?
The person seeking to retain the benefit is the buyer of the house.
Okay, it is the buyer of the house. Yep. Okay.
Yep. But it doesn't matter that the person who exercised the influence was brought in by Mrs. Sadiq's son.
Or not.
It doesn't
whether or not, whether or not she was influenced by him or not is the.
Yes, it's just the position that she found herself in, and all of a sudden, instead of it being a straight bargain between her and the potential purchaser of her house, now she's had somebody introduced into that transaction, whether it's by the person seeking to keep the benefit of it or whether it's by her son, doesn't really matter, because at the end of the day, the result's the same. There was influence, and you've got a person at the end of the line that wants to keep the benefit of that undue influence.
Yeah, and that makes sense, because the influence of her family alone wasn't convincing her. Yeah,
that's right.
So
yes, because she was quite an astute businesswoman.
Yeah,
she had several property holdings of apart from this, so they knew that they had to get in the big guns in order to make her go through with the transaction, which they believed was their duty to do. So I'm not questioning for a moment the religious propriety of all of this. I am questioning, in terms of hard-nosed contract law, the effect on Mrs. Sadiq in this day and age. And as they said in that case, I've quoted this in my answer guide because I think it's such a lovely quote. They quote from Allcard and Skinner. In Allcard and Skinner, they said, the influence of one mind over another is very subtle, and of all influences, religious is the most dangerous and the most powerful. And to counteract it, courts of equity have gone far. They've not shrunk from setting aside gifts made to persons in a position to exercise undue influence over the donors, or that that had been no proof of the actual exercise of such influence. And the courts have done this on the avowed ground of the necessity of going this length in order to protect people from the exercise of such influence under circumstances which render proof of it impossible. They're explaining why the presumption exists here in these cases. And I agree wholeheartedly with what the court said there. It's particularly, it's a person in the position of a religious devotee is in a very, very vulnerable situation, are they not? So the courts are prepared to extend that presumption to people in that position. So you'd impress me with your knowledge of Khan. You would tell me a little bit about the case. So I will just pop in. So the Mufti was the third party. The person on the end of the line seeking to retain the benefit, they asked her to sign the contract and sign a memorandum of transfer. And this was the kicker. They didn't just want her to sign the contract, they also wanted her to sign the memo because they didn't want her to have to get the chance to go back to her solicitor and say, here's the deal I've struck. You know, shall we go about executing the memorandum of transfer now? Because that would have been her window of opportunity to get out. So that was really the thing that sealed the deal. You know, the buyer wanted this all done and contracts exchanged and done deal, all in the one thing. She was smart. Yeah, exactly. She was smart. What if they're also friends? Does that have a major impact on arguing Class 2A, i.e. the reduced rate was because they were also friends? Not in this circumstance, Steph, because we're talking about a Class 2A. So Class 2A, you want to get over the hurdle with that if you can, because then your presumption is working in your favour. If you want to argue undue influence of someone that's not in one of these recognised categories of relationships here, these, then you're going to have to do more work. You're going to have to do the kind of work that they had to do in Johnson and Buttress, okay? So if it's just friends, you have to actually show that the weaker party had the trust and confidence in the stronger party, and that led to a position of ascendancy. So you're going to have to lead extra evidence in order to convince the court that there was a relationship that attracted the benefit of the presumption of undue influence. Okay? So I hope that answered your question there. Like employer and employee. Yes, that's not a recognised category of relationship. John. Prove the undue influence in a presumed relationship. Yeah, so what we've got to do is we've just got to make the argument that poor old Olivia was in the position of, you know, a religious devotee. So what are the facts that tell us? Let me just skim back here to the facts. What facts would you be picking out and saying, well, we've got enough here to show that she was a devotee of the pastor and that there was this reliance which then led to a position of ascendancy? Comments exactly from the past about God being happy, runs to him. Yes, runs to him every time something goes wrong. So clearly she depends on him for guidance. Okay. Here we have comments pretty much similar to what the Mufti said in Khan, didn't you? So I would probably, you'd probably just give me the various things that the Mufti said. And you may well give some description of all cardinals. You might mention Quek and Beggs. That's quite similar. So here you'll be telling me that the pastor said, you know, these things and that she had been seeing him for several years. Don't need those. Home. Okay. She was a devotee for several years, ran to him with all their problems. Appears that she was well known for a reliance type relationship. like Quek and Beggs should probably fall into class 2A. You might want to tell me a little bit about Quek. That was terrible, wasn't it? What was the circumstance? What made her, oh, hang on a second. How does Mufti tell God she did a good thing and that gets entry into heaven? Yeah, let me know. It's something like the power that contract lecturers have. No, that was a joke. Quake and Beggs. What was her position of disadvantage there? Quite horrible. She had a disease. What was it? Yes. She had cancer. She started giving her pastor and his wife all this money, property, and he just took it all. So you might impress me with a little bit of knowledge about Quek and Beggs. And then the kicker here for a good application. Similarly, here, and then you start comparing your discussion of the case law with the facts that you've been given. Okay? Like Khan, we have the pastor telling Olivia, goodness me, what's going on? What? God would be happy, she'll go straight to heaven. And then you'd be comparing in Khan, the Mufti said, blah, 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 blah. Okay, just comparing. And accordingly, it seems like she will be able to establish the relationship of spiritual advisor and devotee, and therefore the presumption. So tell me a little bit about the presumption then. What would the pastor have to show? She knew what she was doing and she acted free and independently of the influence. Okay? Yes? Conclusion. Do we think that they would be able to rescind? We haven't been told that there's anybody stepping in as an innocent third party, have we? Yeah. Yes, John. Yep. Reasonably sound argument for undue influence which would allow rescission of the contract. Does that seem doable? I'll stop sharing now. I'll clean that up and I'll post it up for us later on during the week. Does that make sense to you all?
AJ, could she have been seen to, when the husband said, you know, he cracked it and everything, and then he said, my wife's coming down on his side. So when he's saying there was an undue influence and she's saying, well, no, could that be seen as affirmation or not?
Yeah, I would argue that as that initial resistance, certainly as part of still labouring under the influence of the pastor. The difficulty is if they both jointly own the vehicle, I would imagine that, you know, you'd have to go the extra mile and say, well, she had purported to sell the vehicle. I think her argument, clearly, because this is an undue influence question, we're meant to be looking at undue influence. We're meant to be looking at her relationship with the pastor. But in terms of what would actually go down, if she had already taken the check, it's going to be down to getting the husband and wife to agree on a strategy moving forward. Either they want to honour the deal with the pastor in terms of Olivia is now saying that she's she wants to honour the deal. So either they're going to have to do that or they're going to have to try and rescind. Now, if they both want to try and rescind, they're going to have to rely on the pastor's undue influence of her and the fact that the transaction was concluded basically before the husband was able to intervene to stop the influence.
So her coming down his side is still could still very well be part of the undue influence that we were talking about anyway, that we were dealing with.
Yeah, I think the wife maintains her stance, doesn't she?
Mm. Yeah.
She wants to honour the deal.
Yeah, that's right. So is she still unduly influenced? Obviously, yeah, she's still under that power, I guess.
Yeah, so the husband's coming to you. I'd be saying to the husband, look, you're not going to get anywhere unless you're on the same page with your wife.
Yeah, that was my thing. That's when I was doing my Iraq, I was thinking, oh, I don't know, is she affirming it or is she, like, are they both trying to, because it seemed like he was coming to say, I don't want this to happen, but she's saying, well, I've already done it pretty much. So he's saying, can we go back and undo it, regardless of what the wife is saying, because he's saying she's unduly influenced by him. So I guess that's where it stands.
Yeah, exactly. I mean, practically you'd be saying, look, man, if you're joint owners of this vehicle, you've got to get your story straight. Either you're going to go through with this sale or you're going to try to object to it. And you can't be at loggerheads. I can't purport to act solely on your behalf if you're joint owners of this vehicle. You're going to have to either both agree to sell it and who you want to sell it to. And then come see me, because other than that, you're wasting my time. Yeah. Cool. As John said, you're paying me more money in billable hours than it is worth in terms of the vehicle's value. There's the cold, hard facts, sunshine. That's kind of it. Oh, that's all, folks. Unless you had any other queries on that. It was kind of a simple one because it was so obviously based on Khan and Khan. But it's an interesting exploration of human nature, isn't it, really?
Can the husband sue the wife?
If she decides to go off and join a cult and he just wants to cut loose and get divorced and sue the wife for all of whatever the half of that vehicle would be, can he? Well, it would be all if she had sustained a loss. What if you haven't done family law? Can the case of Louth apply here? No, because she wasn't really influencing her husband to do anything here. She was just purporting to go off and sell the marital asset. I would say that if she had created a loss by selling this vehicle, then the husband would just bring that loss into the marital pool when they were doing their division of property. There's a little bit of family law for you. Jointly and severally. Don't get down to that, John. Gee, you lot, too switched on. Okay, so if you want to go, like I say every week, and go and have a refreshing beverage, go and have an enjoyable dinner and forget all about contract law for a while. Other than that, if you want to stick around, we can shoot breeze about the assignment. If you have any questions, queries, I'm here for you. Hit me with it. Stop crying long enough to talk to me.
I was a little confused. So what I was doing where I went was I went through all the facts and then was advising them on whether they should go ahead. So I probably have to redirect now and actually make the argument for them. So as what I've heard you say.
You need to give an honest assessment.
Yeah.
You need to give an honest assessment, but you need to put your best case forward.
Yeah.
So
okay.
Put it down as though you're making the best possible argument for her case in the High Court. noting, of course, where there will be difficulties or if there will be difficulties.
Yeah. So instead of saying you won't make it because of this, well, you might because of something else. Basically, it can go either way. Yeah.
Yeah, because this is it's no secret that this is a craggy area of the law, and it's been crying out, quite frankly, for some clarification for a while now. And like I said, you've got equally reputable state Supreme Courts saying, yes, we need to grab hold of equity with both hands. I think Australia states was stupid. Well, they didn't say stupid, but...
Well, they nearly did.
They practically did.
Yeah.
And then you have other cases in the Queensland jurisdiction where they're saying, hang on a second, look at Great Peace. That was a jolly good decision. And look at all of the conversation that they have in Great Peace. I think whether you agree with it or you don't agree with it, it's a jolly good piece of curial writing.
Yeah.
It really is a commanding discussion about the drivers behind this area of law. And I particularly like that. And I also like the discussion in Rees and Rees. Has anybody found any other cases that they thought were particularly enlightening?
There was the carpet one, and then there was another one where I'm just trying to think what it was. It was an older one, which was really, really good. I just haven't got my assignment out with me. But I printed out all the cases.
Yep. There's a trilogy of cases which I think are, you've got obviously Great Peace, and you've got Rees and Rees, and you've got Australia Estates, the real biggies. But there's some other really interesting ones. Did you have a look at the footnotes in the text?
Yes, that's where I got a few from in Rees and Rees, because they actually argued that have a look at these cases, Johnson and what's the name? What's the other one? SVAN OSIO versus McNamara was another one.
Mm-hmm.
But mind you, they were all probably leaning a little bit towards the other way, so I'll probably have to look for some that were going the other direction.
Part of the other reason why I got you to do this assignment is so that you can see that their judicial decision making is as much as they like to describe it as objective in contract law. I think this is a great little area to look at, because you can see how judges engage in convenient interpretation of prior case law to suit their own best interests.
Yeah.
And I think you particularly see that in the Taylor case.
Yeah.
The way that they kind of, interestingly, they put a spin on some of the earlier cases like Spinocio.
Yeah.
I think it shows you that, when you get to the end of your law degree and you do jurisprudence, it's really interesting because, you touch on these themes of critical legal theory would say, really judges try to look like they have no agenda, but they have an agenda. And no reasoning, purely by virtue of it being human reasoning, no reasoning is going to be completely objective and free of all your subjective filters, is it? You're gonna come to a conclusion, and you're gonna try and support it the best you can, and that goes for judges too.
Yeah.
So it's really interesting. It's a really, I think it's great because you kind of get to look at the decision making kind of with fresh eyes and see what outcomes the judges are trying to achieve. And it's down to whether you see them as compelling or not too. I mean, unfortunately, I've given you a client to act for that you have, obviously, like I said, they've got vested interests in one way or the other. But you have to make the best case for your client that you can, noting that there may be pushback there will be pushback from the other side.
the other place I found that was really, really good was CCH in the databases, and they have a lot of discussion papers on mistake and that sort of stuff, and they refer to a lot of cases on different things, and I found that was really helpful if anybody wants to go in there and have a look.
CCH.
Yeah.
Mm-hmm. Yeah.
So it's in, I can't recall what the whole database is called, but it's in the library, under the law databases.
Yeah.
But yeah. I'm going to go and argue now for them, which is sad because it's so much easier to argue the other way.
Yeah, and look, like I said, keep my RAC top tips in mind when you're writing it up, because I beware of long discussion of the facts in vacuo that is hanging in air without having established a firm discussion of the case law first. And this is why I don't like great long recitations of facts in the issues section or in the rules section. If you put your facts, issues can be dispensed with in a sentence like we do every week in our tutorials. Okay, save your argument words, save your word count for your argument in the application section. And that goes for rules too. If you start talking about the facts in your rules section, again, you're going to leave yourself with nothing to say in the application section, or you're going to say the same damn thing again and waste words. So treat your application section like we do in our tutorials, treat your rules section like we do in our tutorials, and save all of your word count for your application section. Give me a nice, solid discussion of the case law. Proceed with a beautiful mastery of, the cases that you find compelling in your client's favour, noting that there may be weaknesses if you wish to do so. Yes?
Yeah. Well, definitely that land one, if that, what was it, McNamara and the other one, that one they only didn't reverse it because it had already been transferred, whereas this one here hasn't already been transferred, has it? No. So
no. It's the same as recent race. The transfers.
Yeah. So would you consider that a weakness? If you're referring to that case, they didn't do anything about that one because it had already been transferred, so that they said that they couldn't.
They applied the rule in Seddon's case. So strictly speaking, they didn't have to go into any of what they went into there.
Yeah, okay.
Yeah, which is why the comments are treated with some caution.
Okay, yeah.
So, and that's beautiful, because that's what gives us our grey area.
Yeah.
Isn't it? And really, because the decisions going one way or the other are so finely balanced in terms of what we have currently on the books at state Supreme Court level, you making your best argument for the client is going to involve, you convincing the court that really this is the best way to go, that the cases that support your client's position are the best way to go. And showing me that you can make that kind of an argument will necessarily involve a masterful knowledge of the case law that supports your client's position and why you can argue that it's the most sensible decision for the court, why it's the most compelling, the most legally compelling. Okay. Gotta love grey areas. That's where we make our money, John. Let's not quibble about that. It'd be all too easy if there was a formula. Sorry, Charlene. Did you want to say something?
Yes, I wanted to ask if you can please clarify what it means, what you have in brackets, no bars to the remedial rescission were present. I've never heard that before, and I've tried to Google it, and I'm getting all these mixed different definitions, and I don't even know what that means.
Oh, okay. So if you've done your misrepresentation reading, you will see that when you look at misrepresentation, I'm looking here at 13.12 of the text. So if you have the 2018 version, it's page 482 of your textbook. If you have the 2013 version, I'm unsure what the page number is, but it'll still be 13.12 rescission. And then they go through all of the bars to rescission in 13.12, and they're the ones that we touched on in the tutorial tonight. So affirmation of the contract is a bar. Lapse of time, delay is another bar to rescission. The impossibility of restitutio in integrum is another bar to rescission. Intervention of third-party rights, classic bar to rescission. The contract is completely performed. Now, that is another bar to rescission, interestingly, that Gail was just talking about. That's the rule in Seddon's case. And in land contracts, where you have a contract that might otherwise be affected by a vitiating factor, and you could potentially have argued for rescission, if the land contract has already been completed and the transfer of title has happened, the rule in Seddon's case says, sorry, but you can't get rescission at that late point. Obviously, because in land transactions, you know, before the actual transfer of title happens, there's a long time for all the parties to do title searches and to work out if there is any actual problem with the description of the land or the description of the parish or what's on the title, or do you know what I mean? There's so much process involved with a land conveyance that the court basically says once you've actually gone past the tipping point of transfer of title, well, it's your own silly fault, really. Do you know what I mean? Oh, there you go. Thanks, John. Page 476 in the 2013 version will give you all of your bars to rescission there. They're the same ones that we've just been discussing for misrep and for mistake and for undue influence tonight even. We were discussing bars on rescission. Same thing. Any other queries? What did you think of, did anyone have a look at New South Wales Supreme Court decisions? No? Yes, I'm getting some no's, some yes. There's some cracking cases out there. But I don't, you know, I would say there's a core, obviously, Great Peace, Australia States, Rees and Rees. But there's a few other really good ones. And I would say, you know, if you had a look at all up, you know, 6 or 8, don't go crazy. Don't go looking at every darn case that's happened in every jurisdiction. But if you look at the main ones, like I had like I was looking with you the other week when we went on to Casebase and we tapped in the cases that have considered Australia States. You know, you can pick a core group of, you know, I guess 6 or so that are interesting. Is there anything else that might assist you people? Have I given you more of a paddle now?
Yeah. Much clearer. Thanks.
Okay. It's really, I guess the uncertainty really is around, you know, it's really just because you guys haven't done that many assignments at this point. is where your uncertainty kind of stems from. But if you read my IRAC top tips, that'll set you going on a decent path in terms of the actual write-up. And, don't give me great long discussions of facts without first having given yourself a framework, that is the case law that's going to guide your discussion of the facts. Okay, your facts will have far more punch and persuasion if you've presented them to me after you've presented your knowledge of the relevant case law, because then you can pick out all of the juicy bits of the case law and then compare with the facts that you've got at hand, and you can say, well, as I do often in the tutorials, similarly here, da-da-da-da-da-da. So you're comparing and you're contrasting. That's what the doctrine of precedent is all about, isn't it, really? This is the stuff that law is made of. This is the fabric of law. It's knowledge of the cases and trying to match your client's case, the facts of your client's case, up as closely as you can to what is existing out there, the existing case law that's in your client's favour, and using that to your best advantage. Okay, as I said, to some extent, there's no right and wrong answer, except that I think the answer is fairly clear. What will sort the sheep out from the goats, I guess, is how clearly and convincingly you can make your argument for your client. Like I said, you've got to bear in mind a few things. A, you have a client and you've got to be making the argument in their best interest, not in what you think is the fair and just outcome of the situation. You've got to be arguing in your client's best interest. And you've got to be making that sound like it's the most logical and reasonable thing for the court to do, given the precedent that's on the books. Okay? And that's where your mastery comes in, because it will become very evident which students have really delved into the case law that I've told you to read and know it like the back of your hand, and will be able to match it up very nicely with the kinds of things that your client will be wanting to say, and those that are having real difficulty with the injustice of the situation, given that you're acting for the client that's perhaps seeking to retain a benefit that you might not want them to retain. So Malice is claiming no common mistake. Dirtbag. Well, I think the argument is a little more nuanced than that, Tammy Lee. I love this stuff. You see, you will look back on this assignment and laugh one day. I can guarantee it. Not too far into the future. He's all right. I'll vomit. No, you won't vomit. You won't vomit. I think this is good. I think it's helping you to grapple with the whole mind-blowing thing of having to act for a client where you feel like, because I originally had you acting for benevolent, but then I thought that's going to be too easy and it will be playing into people's gut feel as to what they should be arguing. So I'm gonna make you earn your money, your theoretical money here, and see how you go. My pleasure. No, I think you'll do. I think you'll do quite well. Do have a look at, as I said, the bit that I want you to have a look at particularly is that discussion from page 573 to 577 in the 2018 text, 14.4.2 equity. It's got there in the chapter on mistake. Have a look, know those pages well, and make sure that you've gone through all the footnotes there, 573 to 577, because they will assist. And you know what? I would recommend, if you haven't already, forming a little chat group off the Facebook page. If you are chugging away, because you all should be chugging away on this brilliantly well by now, you should be well into reading your case law. I would suggest forming a chat group if you're on the Facebook page, and just bashing it about on there. I'm happy to moderate that if you want, but you don't have no Facebook. I can understand that. I'm more than happy for you to. Do you want me to do a separate little forum on Moodle for you? Yeah, that I'm talking like a student. Get your feet wet and get in there and discuss. Sure, I'll create a separate Moodle forum that is mainly, I'll still moderate, but that's specifically designed for, because I do have a Q&A forum there for this assessment piece, but I think some people have thought, because it's been mainly me that's posted in there, I think some people think that it's just, it's not really for back and forth discussion, it's more for, asking me questions to clarify things, but I'll create a different one for you. Yeah, okay, Tammy Lee, that's fine. I'll create that forum for you tonight after I log off, and yeah, go forth and multiply. I'm happy. Look, I think gone are the days where law research was a solo thing, and assignments were, one student found that mystical case that the lecturer hoped that everyone would find and got the HD and everyone else missed out. I think legal research has moved on a long, long way from there. And I think, I think legal education has moved on from that. Because in practice, if any of you go on to practice, you will know that when you do a big advice for a client, it's never a solo affair, ever. Even if the partner's doing it, the partner will get one of you guys as a graduate to write most of it. They'll finesse it. You might have the input from a few other people, a few associates in the section. Might have their say on the advice as well. And you knock around ideas. It's not ever a case that you will send out a decent advice just having jotted it off your own head. This is why and I know I'm waxing lyrical a bit, sorry, if you want to leave, feel free. But this is why I find exams difficult conceptually, because it's never the case in practice that you would be asked to advise a client after having been given a set of facts you've never seen before and go to woe having knocked out an advice in the space of 50 minutes. It doesn't ever happen. And if it does happen, let me tell you, you would be opening yourself up for some a legal professional indemnity claim, because it's not good practice. If I had the magic, I'd share it. Call me Harry Potter. But this is the thing. And if you get into a forum and you get in there and jump in and have some decent discussions, it not only helps you in terms of the way that you're thinking about the problem, but sometimes it's just the case that law is such a talking discipline that it's not really until you hear yourself saying something or saying it on a forum that you kind of get what you actually think about something. And then when someone else throws in a different perspective, it actually really refines the way that you can think about things conceptually. And that's why I think, the whole practice of law and legal education has changed from what it was when I went through. For the better, I think. So I'll create that forum for you. Is there anything else I can do in terms of providing you with guidance? Okay, we'll go forth and multiply. As I said, really this will come down to the convincing nature of the arguments that you can make given the case law that's in your client's favour. And that's the mastery of case law, and your ability to use that to your best advantage is key. So, and I would be saying, if you were acting for benevolent, I'd be saying the exact same thing, because the beauty about being in front of the High Court, as I said, they can go one way or the other. It's 50-50 on this. So it all comes down to you, the beauty of your arguments. Okay, I hope you're feeling a little better. If I can do anything else for you, you just let me know. A lot better. That's good. I like to see that. Happy campers. Okay, well, I'll get in today. I'll hop in right now and create that for you guys and knock yourself out. If you want to do a chat group off of the Facey page, also, that's fine. But until then, I look forward to having a chat with you in the new forum. And if you need anything else in the meantime, you know where I live.
Thanks.
Bye, guys. Bye.